Okay, everybody. Today we're going to talk about something a little bit longer, and it's called administrative law research, and it's long because it's expansive, and it has to do with the roles of agencies. And you have to become familiarized with this term: the Federal Register, the CFR, or the Code of Federal Regulations, and the Federal Administrative Decisions, because those are all important things that need to be taken into account when you're doing administrative law research. So there are three sources of laws, legislative, judicial, and the executive. And the executive now is combined between the president, the cabinet, and the administrative agencies. These agencies are established by the legislatures, and agencies are usually organized under the executive branch of government, but not necessarily always. Often they're associated with the cabinet position, conduct legislative, executive, and judicial type of activities, and exist in both the federal and the state levels. So you see them, that administrative law applies to both federal and state law. Examples of executive branch agencies are the EPA, the Department of Transportation, Federal Reserve Board, Department of Agriculture, etc., including even the United States Postal Service. Because of the scope of congressional delegation of authority, each agency is unique in its structure, its personnel, and the nature of its regulations. So it even has its own standard operating procedures within its own agency. Unless talking about a specific agency, this administrative agency regulations and decisions must be discussed in broad generalizations again, because each one has its own promulgation of rules. Independent administrative agencies, they call it the fourth branch of government. So we have the executive, the legislative, the judicial, and then we have independent administrative agencies or administrative law. There are also agencies that are created by Congress, are part of the executive branch, but are not under the direct control of the president. Many of these are called independent regulatory commissions. This is important. Not everything falls under the executive branch of the president. Sometimes Congress intends for a agency, and it had to be an independent regulatory commission. So the president appoints the person, but cannot remove the commissioners except for costs specified under enabling statute. So under some kind of a major problem or scandal, then for fair due cost, then you will be replaced. These agencies are often called the headless fourth branch of government, again, because they can work independently of the president or the executive. Some of these agencies you can see include the Civil Aeronautics Board, the Equal Employment Opportunity Commission, the Federal Trade Commission, the National Labor Relations Board, Security and Exchange Commission, et cetera, et cetera. So you can tell that these are very important, very powerful agencies that are basically self-controlled. These agencies may have several different names, in fact. For example, what they call the board is actually the National Labor Relations Board. The commission, actually the FCC, or the Federal Communications Commission. And the corporation is actually the FDIC, or the Federal Deposit Insurance Corporation, which is basically the security agency behind banking. Authority is what they call the TVA, or the Tennessee Valley Authority, and Department of Administration is called the department, and the administration is called SSA, or Social Security Administration, and the EPA is actually called the agency. So they have common names that have been given to these particular agencies. The legislature granted rulemaking authority of these agencies. The Congress decided to promulgate these regulations with administrative agencies and enact enabling statutes that establish the scope of the agency authority, telling it exactly what you can do. This is your wheelhouse, you must do these things. Environmental Protection Agency to protect the environment, environmental law, etc. Presidential executive order may also delegate authority to promulgate regulations to administrative agencies. So the president can decide to have an agency send and conduct the promulgation of a particular regulation. The judicial Congress may also grant power to hear and settle disputes arising from the regulation or the enabling statute. So the Congress, in fact, gives power to do the basically back and forth between parties when there is issues with a particular agency's regulations. This happens, for example, with agencies such as the USCIS or the immigration courts. They're actually work for the agency instead of working for the judicial branch. The executive Congress must also grant power to investigate and prosecute violators or regulations. The role of the administrative agencies, again, they have three different types of roles as they do similar to those other three branches of government. They can be legislative, promulgating regulations, big part of what they do, and giving information that has to be given to all the parties that are involved. Judicial conducts hearings to determine guilt and mete out punishment to violators of these regulations. And executive, enforcing these regulations by prosecuting violators by disciplinary actions and stop orders, which is one of the things that make them so unlikable. The role of the administrative agencies and the outcome of the agencies include more rules, more regulations, licensing. They can give you a license and they can take away a license. Even hairstylists and barbers have to go through licensing requirements, and they can be made harder or less hard. Advisory opinions, there are authoritative interpretations of statute and regulation, but they're not binding, but they really will have a lot of weight with especially local or state agencies or organizations. Orders are the final disposition of any agency action other than rulemaking and decisions which adjudicate controversies arising of the interpretation of statutes or regulations. They are issued in the same manner as court decisions. Now, let's compare what a statute and a regulation is. The statute is actually passed by Congress. The regulation is passed by the agency. It's an executive type thing. The statute provides for broad social and economic goals and legal requirements, but the regulation actually gets all the power from its Congress, and it prescribes specific legal requirements to meet congressional goals. So basically, they are there to institute, to enable, to make happen whatever the Congress wanted to happen. Get their power. They're reviewed by courts for constitutionality. All statutes are, but also the regulations are reviewed by courts to determine constitutionality, limits of delegated authority, and whether they're arbitrary and capricious. But remember, there is a principle of exhaustion, or what's called Chevron deference, after a case with Chevron in it, in which it requires that anyone who is going to litigate outside of the agency must exhaust all of the potential steps that are given by that regulation. And then after that, they can appeal to the regular court. But not until then, the courts will not hear it. They will not even let you in. So in a statute that represented democracy, Congress acts to represent the will of the people, whereas in the regulation is more a participatory democracy, and the agency must seek and consider public comment. So that's why you see a lot of signs, a lot of information, requesting information, telling you about hearings when it comes to administrative law. The process of promulgation regulations, and there's going to be a little map and chart that comes ahead. It's really interesting. It comes from depending on the authority that has been given by the legislative, and then the congressional hearings and reports. Then there are court orders, there are executive orders, the Office of Management and Budget circulars. That's a lot of reports and studies. The agency acting on its own initiative can promulgate some more regulations. Emergency situations, technological developments may prompt the agency to come up with new regulations. Political pressures are commonly the reasons why there are more regulations or less. The Federal Advisory Committee also recommends, so the part of the government, committees that are given by experts, and they give their advice, and petitions and informal requests from affected parties. Okay, the rulemaking process again, the rule regulations proposed, the Office of Management and Budget sends out their report saying, well, how much it's going to cost, what's involved. The proposed rule is published in the Federal Register. Comment is invited by everyone's involved. So there's actually notification given, and then the Office of Management and Budget re-reviews the regulation after they've been given more input, and the final regulation comes out in what we call the Federal Register. The Federal Register starts as a single sheet, and then they get compiled and become the Code of Federal Regulation, or also commonly known as the CFR. The effective date usually are 90 days or so, but 30 days minimum for most regulations, 60 days minimum for major regulations, but 90 days or less is usually the time for a regulation to take place. There's no minimum for good cause. An agency may delay or withdraw regulation before it becomes effective to let people know, or for other reasons. Agency submits a regulation to Congress and Government Accounting Office, which can nullify the regulation that are found to be appropriate, and the regulation is placed in the CFR. See the steps, how they go. For example, one will come out from the president. He will send an executive order and they tell the agency sends it out to Federal Register and will propose regulation. And here we are. or it can come from Congress. They make a public law, basically a statute. They give delegated authority to a particular agency. They publish it in the Federal Register, and they begin the proposed regulation. Okay, afterwards, they will go through congressional oversight or judicial review after the principle of exhaustion that we just talked about. If public comment is urged at almost all the steps before the promulgation of a particular regulation. Okay, so the role of agencies, the Code of Federal Regulations, the federal agency, and the federal legislature in 1930 began addressing numerous economic and social problems. These agencies were created to formulate the regulations to implement the congressional intent, and the public needed notice of this regulation so they can have their say in what belongs and doesn't belong in their backyard. And of course began to rule that these secret laws were a violation of right of due process under the Constitution. So they made it so that it has to be open, public, and available for the people. A centralized final publication system was needed, and that's where the Federal Register Act came out in July 26, 1935, and that became codified in Title 44, Chapter 15 of the United States Code, or United States Code Annotated. That's the Westlaw version, the United States Code Service, it's the Lexis version, which provides a daily Federal Register to publish executive agency regulations. The act was amended in 37 to create the Code of Federal Regulations, which is what we mostly use. So it's now the ECFR. So if you just Google ECFR, you'll find the publication of the Federal Register that has all the notices of the regulations, the contents, the legal effects, the text, a true copy of the actual image of the document. It gives the legal authority of the agency, the regulations, and gives you dates and shows you how and why the Code of Federal Regulations will be amended and what is taking place. The APA is the most important secondary part of the statute because this APA requires specific steps to be taken before a change in a particular regulation, and that includes the open public notice so that individuals can comment. When those steps are not followed and the operating procedures not followed, the APA comes out as a cause of action that can put a stop on the particular regulation completely. And this has happened with federal regulations such as the not DACA but DAPA for the parents of immigrants that were detained because of the not being published correctly under the Administrative Procedures Act, which is a very powerful law. The due process and public participation requirements of the APA is that they must give notice of the proposed rule, must take public comments and respond in the final rule. The regulations cannot be enforced or if not published in the Federal Register, they have to give public notice to everybody. They cannot be effective until 30 days after publication, usually no more than 90 days, but about 30 days. And they must publish the statements of the organizational procedure to whom the contact for comment in the agency. They must also state the legal basis and purpose of the regulation. So you see how complex the APA and the steps that must be followed by each agency when a regulation is coming out. They're published every weekday except on federal holidays. The daily issues from a year constitute a single volume, and then they become the CFR. Annual volumes of the Federal Register can exceed 60,000 pages worth of legislation or regulations, and the contents are required to be judicially noticed by the United States Code, Title 44, Section 1507. Okay, the Federal Register in each issue has a table of contents, the presidential proclamation, all the executive orders, administrative orders, agency final rules, the proposed rules and notices, Sunshine Act meeting notices, meaning public, giving the public access to see the entire process, and unified agenda of federal regulation. And they also have reader aids as part of the law to provide different formatting for individuals that have disabilities to have the right to review the regulations. The Federal Register order material in each issue, and it tells you right here, basically the hierarchy, presidential documents up on top, orders, proclamation, other documents, rules and regulations having the legal effect, then the proposed rules and regulations, then notices and notices Sunshine Act meetings. Okay, presidential documents, again, many presidents as of late have basically ruled by executive orders, and they'll be published in the Federal Register. This proclamation must be published in the Federal Register as well, and the administrative orders and miscellaneous documents are optional. Those are not having to be published, okay? Federal Register presidential documents on Westland, they're available on many of our databases. And in the Federal Register table of contents, if you can see, this is how they will become arranged. In the table of contents, it will have by agency, and then for example, FAA, Federal Aviation Administration, in the flight crew compartment, and then it gives you a page number, and then you will have the specific regulations that go to that. The CFR parts affected in this issue list the document in numerical order, appears at the front of each print issue, indicates whether the document is affected. The CFR parts of regulations or proposed regulation, a big difference, and cites the page number where the relevant documents begin. So here, page 2112 of the CFR affected by this issue, you go to there, and then you will begin your research, okay? The final rule regulation published in the Federal Register is gonna come out under the CFR, and amending other regulations telling you about a particular one. This is what they found, okay? There are reader aids, again, to tell you how to find it. And for example, if it's a particular regulation has a name or another service, it tells you how to find it, and it gives you a table so that if it has been changed, that you'll be able to get the most recently enacted public law, okay, customer service phone numbers, etc. Indices and previous federal registers are also available through Central Index System, the CIS, the Federal Register, and you can find all of this material at most government depository law libraries. Okay, cumulative annual Federal Register for 2001, and you see that each one, this LSA, for example, comes up as another publication, is printed each month, is key to the Code of Federal Regulation parts and sections. It's also available online for free. You can look at it and you can see the index and the Federal Register, all the different promulgations of different agencies. The final rule is published in the Federal Register on January 15 and amending other regulations, and it tells you the action of the regulation, the authority, United States Code annotated, and it gives you the section of the actual regulation. I hope this is helpful and that you've been able to understand how administrative law can become very big and voluminous. However, it is very telling, and in legal research, it can really be a tremendous tool. Thank you so much, and I hope you enjoyed it. Let me know if you have any questions. Thank you. Bye-bye.